I often tell my clients when I'm meeting with them, and lately via Zoom, but usually in one of our conference rooms, that the power of attorney is the most important document there is. I share this with them because it literally has the power, and no pun intended there, but the power of attorney has the ability to help tremendously or to tie your hands and force unnecessary stress, unnecessary expense, and unnecessary delays. It can help or it can hinder. It can be a friend or it can be a foe. If done properly, the durable modified power of attorney, as I call it, can be a significant asset when it comes to aging and estate planning, elder care issues, and of course, asset protection. It could be that great friend allowing your wishes and intentions to be efficiently carried out by someone that you trust should you ever lose mental capacity or develop some form of dementia. Should this critical tool not exist or not be implemented the right way, then the exact opposite can occur. All right. And any number of negative things can happen. For example, you won't have access to assistance, all right, with any of these elder care issues or asset protection concerns. That trusted person won't be able to help, and those that care for you will be thrust into an expensive and drawn out court proceeding that doesn't have any type of guaranteed outcome, because the court gets involved and you lose all control over what's happening. If that happens, you and those around you will realize how quickly a bad power of attorney or its non-existence altogether can negatively impact you, your life, and theirs. It can soon become an enemy, if you will, that causes great regret and stress. All right. We've met with clients time and again without powers of attorney in place at all, and that's usually okay. We can typically fix that as long as there's still mental capacity to do so and to sign one. But we're also seeing almost weekly powers of attorney that were done incorrectly, and they're just time bombs waiting to go off. This is such an important issue, and the fix is usually pretty straightforward. So I felt that it was important to actually spend a whole webinar session on just this power of attorney tool, this document, to stress how critical it really is. All right. So let's get back to the actual presentation, and I'm going to share my screen. Let's make sure that's happening. All right, so again, I'm going to ask for a little involvement. You can see my screen, the title screen again. Let me get a thumbs up, please, or an okay in the comment box, the question section. Thank you. All right, great. So let's get started. Okay. There's always a little technical part here to get things started. So, as I was sharing in the beginning, this seminar is going to be a little simpler and shorter than the previous ones because it's about one simple strategy. Have a backup decision maker. Period. End of story. Have a backup decision maker. That's what this is all about. It can get complicated, and there are ins and outs, and there are technicalities, and I'll break that down for the most part today. But the concept of having a backup decision maker ready, willing, and able to act is pretty simple, right? That's what this is about. Okay. So, what exactly is a power of attorney? Well, New York State has a statute that created the power of attorney form. It's what's called the General Obligations Law, GOL, General Obligations Law, created a statutory, what they call short form power of attorney. All right. And the bottom line is that a power of attorney, as I've already said, is a tool. Okay. It is a tool so that you can have somebody assist with legal, financial, and your personal affairs. If you have it done properly, which I'll get into today, then somebody can help with your legal issues, your financial issues, and your personal affairs. Okay. A power of attorney is not for healthcare decision making. In New York State, we call that document a healthcare proxy. So the healthcare proxy is for healthcare decision making. The power of attorney is for finances. It's confusing because other states call the healthcare document a power of attorney for healthcare. If you ever see that in New York, it came from outside of New York. All right, we're the healthcare proxy. And a power of attorney has to have two parties involved. It always has to have a principal. That's the person creating it, right? That's the client establishing the power of attorney. Then you have the agent, okay? You can have co-agents, you can have multiple agents. The agent is a fiduciary. And what that means is they have to do what is asked of them under the responsibilities of the power of attorney, or they have to do and act within the best interests of the principal if they do not have specific directions or instruction. So that it's a fiduciary position and they have to act in the best interest of the principal. Okay. The agent that's appointed should 100% have the trust of the principal. The principal has to trust the agent. There has to be a level of maturity and responsibility and confidence in the agent. When I'm sitting with parents, they'll typically, husband will appoint wife and vice versa. But then we always get into successors. And the important part is to realize you don't have to pick somebody just because you think you have to pick them to be your agent. For example, you don't have to pick your oldest child to be your power of attorney agent if they're not the most organized or financially responsible person. You can pick anyone you want. You can pick your youngest daughter. You don't have to pick your oldest daughter or your oldest son, okay? It's about the person that has it together and can help with these financial responsibilities, okay? You can appoint more than one agent. So it's simpler if one principal, of course, appoints one agent, but you can have co-agents, all right? You can have two or three agents. We generally don't like to go more than two agents, but you can. When you're picking more than one agent, the principal has to decide whether or not the agents can act separately, which makes it easier for them, or whether the agents must act together. All right. So if there's two or three agents, something the principal has to do, assuming the document was drafted properly, is initial a different section that states that talks about my agents can act separately. And again, that's typically the way to go as long as you've got two good agents that, again, you trust and get along and are each responsible. Or if you want the check and the balance, you can actually appoint them to act together. All right. So there's one form, as I said, the General Obligations Law created a New York statutory short form. And I chuckle inside every time I say statutory short form because it's not short at all. It's a long form, all right? But it's called the statutory short form. There are different versions and different types of powers of attorney, okay? There is what's called a general power of attorney. That is where it's not for planning circumstances. It's more for everyday, plain vanilla type of circumstances. For example, if your wife was going out of town and you had the closing to sell the house was happening, a general power of attorney would be signed to handle that situation. Okay, general power of attorney is not usually for, again, it's not for planning and protection and aging concerns. Then you have what's called a durable power of attorney. The durable aspect is crucial. It's what has to happen in our world. When we're talking about estate planning and elder care, the power of attorney must be durable. And what that means is that if the principal should ever become incapacitated, the power of attorney remains valid. Okay? So the concept is this. If Principal Steve appoints Agent Bob to go do something for him, if that Principal Steve loses capacity, well, then so does the agent. All right. He no longer has an ability to act on the principal's behalf because there's no mental capacity. The introduction of this durable concept means that Bob can still act as the power of attorney agent because the power of attorney is durable. The document will say this power of attorney will remain effective even if I should lose capacity. Okay, crucial aspect when it comes to planning. So it must be a durable power of attorney. There's also what's called a springing power of attorney. Not used that frequently. We don't use the springing power of attorney, if at all. What this is, and the concept is good, but it doesn't work that well practically. So what a springing power of attorney says is that it is not valid when it's signed. It only springs into being upon a future contingency. such as the principal losing capacity. Okay. And typically, the doctor for the principal would have to sign a statement that the principal can no longer handle their affairs, thereby springing the power of attorney to life. It makes things complicated in the real world. And the underlying thought that if you're going to trust your agent in 10 years to handle your affairs, just trust them now. Having to jump through hoops later makes things a little more complicated. Not to mention, the doctor may not want to sign a form like that. So then the power of attorney may always remain invalid or not alive yet. So again, springing powers of attorney exist. We generally do not use them at all. We like the power of attorney principle to pick an agent they trust and can confide in and let it be valid immediately. All right. So which one is best? Again, as I think I shared properly, is the durable power of attorney. That is the form that we would start with as our base statutory short form. So a little bit of history. What we have in New York is a little bit of, convoluted history as far as the power of attorney. So the power of attorney was always a simple form, which just said, I, principal, appoint you, agent, to handle A, B, C, and D. It could be, that list can be expanded. It could be tailored a little bit. And that was always important to do in the concept of planning. The statutory short form really just has basic powers and authorities that are being delegated: banking, real estate, some small gift giving for holidays and birthdays and so forth. It does not get into specifics such as tax planning, retirement planning, Medicare, Medicaid, asset protection, trusts. So the basic form, again, convoluted history. One of the biggest changes was, or throughout the years, is there's always parentheses on your power of attorney as to whether you initial to give the power or you don't initial to give the power. That was confusing through the 80s and 90s when the powers of attorney, of course, were being used a lot back then as they are now. But what happened in 2009 is the New York State Legislature decided that they wanted to take an approach that was meant to be a little more protective of the principal in regard to financial exploitation. So the power of attorney form was revamped and introduced in 2009 with what was called a statutory major gift rider in 2009. So the gift rider was this separate form where the principal would actually acknowledge that the agent can make certain gifts to different people. Okay. That form had some problems and it was re-released. It was tweaked, if you will, and re-released in 2010. So the form that's currently in effect is the New York statutory short form released in 2010. Okay. Again, they made some tweaks. They changed the name of the statutory major gifts rider to just the statutory gifts rider. Okay. And again, some other changes as well. As I'm saying, as I've been describing this, there are two parts to the power of attorney short form. There is what's called the main part, or what I call the delegation of authority part. That's where the principal is saying, okay, agent, you can do A, B, C, D, and E for me. That's typical. That's the standard historical power of attorney. Then there is, as I've been describing, this statutory gift rider. The statutory gift rider is where, the principal is specifically saying the agent can make gifts or transfers, or in our world, asset protection or income protection steps, all within the gift rider. Okay, so the gift rider itself is broken into three parts. Part A says that the agent can make gifts to anybody, including within the family, of course, up until the amount of the annual gift tax exclusion amount, which is currently $15,000. So Part A says agent can gift up to 15. Part B says agent can gift and do other planning and protection over $15,000. And Part C states that the agent can actually make gifts to themselves. Okay. Not always the right thing to initial and the right thing to implement. It depends on who the agent is. In a typical situation where we have a husband and a wife, perhaps spouses and children, then yes, you usually have the agent be given the authority that they can make gifts and transfers to themselves. In some circumstances, we'll have a sibling because there's no children. and that sibling may not be an ultimate beneficiary. So they are not given the right or the authority to make gifts to themselves. Okay. So all of those discussions have to happen with your attorney that focuses on this. All right. This is the conversations we have with our clients when we're getting engaged to do different planning for them. Okay. Um, then we have the modifications. This is probably the most crucial aspect of what happens. The modification sections, so each half of the power of attorney, the main part and the gift writer, both have the ability for modifications to be added. How does the principal modify the form to expand it to make it more comprehensive for their particular needs? In our world of elder care, we are expanding and literally blowing up these modification sections. As I tell the clients, we throw in the kitchen sink. We want to make sure that we cover asset protection, income protection, retirement accounts, trust funding, any type of income reallocation as far as pooled supplemental needs trusts for Medicaid purposes. That perspective of aging and elder care and tax and Medicaid, that's what goes into these modifications. And as we go, I'll explain more, but we sit with clients, some without the power of attorney, but some with the power of attorney with no gift writer, and some with a power of attorney and a gift writer, but no modifications. All of those are very harmful circumstances. Okay. So the purpose of today is to share, all right, what a good right power of attorney is going to look like. All right. So let's talk about what makes it good and usable, as opposed to one that can hinder and ultimately hurt. Okay. So the right power of attorney, there's 5 different factors that I consider that build it to be a right and good form that will help in the future. Obviously, it has to be that statutory short form. It has to be that durable form that I've been talking about. It has to have the gift writer. The gift writer is not something that gets signed a year later. It is not something you can put onto an old power of attorney. Just this week, sitting with a client on Zoom, they sent it over. We have like a 2007 power of attorney, but there's a 2015 gift writer. It doesn't work that way. Everything has to get done at the same time. It's one tool, it's one document. Okay. There have to be the correct expanding modifications built into part 1 and part 2. If they're not there, then our hands are tied and the agent's hands are tied as to what can happen for income protection and asset protection. When we're looking at powers of attorney that clients bring in, potential clients bring in when we're first meeting with them, we have to go through all this because there's a mindset that says, all right, I have a power of attorney, check the box, I already did it, I'm fine. But it needs to be reviewed and it needs to be examined because a lot of the times, seriously, a lot of the times, it doesn't have the gift writer or it doesn't have the modifications here or the modifications there, or it's the wrong modifications altogether. Very crucial that it has the correct modifications. The 4th important part is it has to be executed properly. There are places for signatures for the principal. There are places for notaries. There are places for witnesses. There are places for the agent to sign in order for it to be valid. The initials are the ones that get screwed up the most. Depending on, the gift writer and the 3 sections there, initials are usually required in B and C. Within the document itself, initials have to be within the agents act separately or the agents can act together. Okay. If there's a need for compensation, if there is a need to appoint what's called a monitor, which is somebody that can actually oversee what the agents are doing, all this has to be built in there and executed properly. If you're not sitting with an attorney that does this every day, and God forbid you're just not sitting with an attorney at all, you're going to run into some issues and complications because it is confusing. Okay. So it must be executed properly. And an obvious one, but I'm putting it out there because we all read the paper and hear about the stories. The agent has to be trusted. Okay. Again, maturity, financial responsibility, disciplined, their own financial affairs are in order. They're close to you. They communicate with you. You can rely on them to help with different things. That is the agent you want to have help. And that also applies to a successor agent. Okay. I didn't want to do it as another category. I'm trying to keep it as simple as possible. So a trusted agent and a trusted successor. You always want to have a successor backup agent. And again, that can get complicated because you could do more than one as successor. You can allow them to be co-agents, separate, or co-agents together, or you can have agents in order, 1, 2, and 3. All that gets built in there. Okay. The power of attorney is not a simple sign and check the box and you're done. There's more depth to it than that. Okay. So this is what makes a good and right power of attorney that'll be helpful for aging and elder care, asset protection, estate planning, and income protection. Now, the wrong power of attorney. This is the obvious part. It's going to be the wrong form. Again, I just saw a 2007 power of attorney main form, but a gift writer from 10 years later. You need the right, correct form. If it was signed in 2011, it has to be the 2010 form, not the 2009 form. All right. All those little technicalities. Not having a gift writer, that's a mistake. Missing modifications, that is a mistake and will render the power of attorney ineffective as far as elder care and elder law concerns. Having it executed improperly. We've had clients that accidentally, so when we're there overseeing, initial here, explain this, explain that, the client might just inadvertently initial in the wrong spot. And then what are we doing? Well, we're reviewing it before they ever leave the office. We're reviewing it as it's happening. We're reprinting it and redoing it. Properly signing, initialing, notarizing, witnessing, agent signature, all that has to happen properly. Picking the wrong agent. I've said enough about the importance of having the right agent. The wrong agent, they're going to have access to your funds. Yes, they're a fiduciary. Yes, they can breach their fiduciary duty. You don't want to go there. You don't want theft. You don't want any criminal acts. You don't want that that agent going in there and doing something that they're not supposed to do. All right. This is when you run into problems. This is when the power of attorney becomes that foe in as far as the title of our program today. Now, what happens if there is no power of attorney at all? Well, we have to ask the first question, and that is there capacity to sign one? And if so, then you get the plan done immediately. You go to an experienced elder care attorney. This is what we do, and we will make sure if there's capacity, we can have a new power of attorney signed. If there is no capacity, okay, and let me say this, a diagnosis of dementia or Alzheimer's does not mean necessarily that there is no legal capacity to sign a document like a power of attorney. It may mean that, but it doesn't necessarily mean that, okay? The doctors can have their diagnoses that can be legitimate and valid, but there has to be a level of capacity for a client to understand what is the power of attorney, what's the document, what does it do, what are the ramifications of it. And if they can get that and understand that, even with the diagnosis, then we're signing the power of attorney, okay? Now, if there's no capacity, if dementia has reached to a certain point, or if the stroke was so extensive, there's no ability, then you're going to be forced into what's called a guardianship. And this is the number one reason I jump to, and a reason why you have to have a power of attorney, because if you don't, and you don't have capacity, you're forced into a guardianship. A guardianship is a court proceeding, all right, where those that are close to you, support you, love you, will have to hire a lawyer, petition the court to be named guardian, perhaps of the person, which means for healthcare decisions, and or guardian of the property, which means to take care of your assets. It is meant to be a fast, expedited process. It is not necessarily. A guardianship proceeding can take 6 to 12 months. And if it's contested, and what do I mean by that? Well, if mom is alive and dad's already passed and mom doesn't have a power of attorney, or mom has the wrong power of attorney and no capacity, then Mary is going to say, okay, Mr. Attorney, I need to hire you because I need to be mom's guardian. Well, the son is going to say, you can't be mom's guardian. You can't even take care of your dog. I'm not going to let you take care of mom. I should be the guardian. And now you have a contest. You will literally have litigation before the judge. There will be witnesses, etc. and it can take forever and cost a tremendous amount of money. A typical guardianship is anywhere from, let's say, $5,000 to $10,000 and can take about 8 months. If it's contested, where you have people arguing and fighting, you're talking $10,000, $20,000, $30,000 in fees. All of that can be avoided with the right and proper power of attorney. Okay. Another risk with not having the right and proper power of attorney is when you get into the guardianship world, you lose control. The court will appoint perhaps an attorney out of the blue to represent your mom. The court will appoint another attorney, typically to be a court evaluator. And all these bills are just adding up and adding up. And that court evaluator will interview what's called the alleged incapacitated person. That could be mom. And they're going to make their recommendations. They're going to make a report and make the recommendations to the judge. The judge does not have to appoint you to be the guardian. They can pick somebody from the outside, from the community, to serve as guardian, and you lose control entirely. 100% guardianship should be avoided by having the right comprehensive power of attorney in place. Okay? So if there's no power of attorney, that's how we end up doing this. Same situation. If it's the wrong power of attorney, meaning it doesn't have the gift writer, or it was executed improperly, or it doesn't have the right modifications. First question, is there capacity? If yes, then we are doing a very comprehensive power of attorney as soon as possible. If there's no capacity, we're back to the guardianship and we're back to that guy or that lady. All right. And they decide what's going to happen after months and months of stress and delays. So let's say you have the power of attorney. Okay, it's completed. You've taken care of it. How does that work? Well, you should be implementing the power of attorney in counterparts. There should be at least 2 original powers of attorney. Why? Because if you lose one, or if you give it to the bank to make a copy of it and you forget about it and they keep it, at least you'll have another one. Okay, so we always do duplicate original powers of attorney. Now, how do you keep them safe? Well, some options are you can leave the original powers of attorney with the attorney that drafted them. We generally do not keep powers of attorney or original documents even for the clients. Number one, because it's your documents. You should have control over them and you should know where they are and have access 24/7. Number one. Number two, if we're holding it for you and you need the power of attorney on a Saturday or Sunday, we're not open. Okay, so then what are you going to do? You have to wait till Monday, and then we have to get it from storage or from the file. It just can be a little cumbersome. We'd rather the family keeps the power of attorney stored safely. Now, we also don't want or recommend that you put the power of attorney in a safe deposit box, really for the same reasons, plus one. The main reason is on a weekend, you can't access it. Number two, if it's your safety deposit box and you're trying to get your agent to go in there, they're not going to have access. We have heard 1,001 stories about banks, freezing the box or not letting the agent in there. So stay away from the safe deposit boxes. The best place to actually store your original wills and powers of attorney and healthcare proxies and trusts is a protective, maybe even fireproof lockbox or safe within your home. All right. A metal file cabinet can work. As long as we don't have floods and fires, that should work just fine, okay? You want your agent to know where the documents are, how to access them. You can, in certain circumstances, give the originals to the agent. Obviously, if it's a spouse or if it's a trusted child that's nearby, they can hold your originals if you're comfortable with that in a safe, protective lockbox or safe. Generally speaking, the family, the client holds on to them, and the agent should know where they are, okay, how to access them, or know where the combination is or where the key is to access them, okay? Now, where do you get the right power of attorney? We have a little quiz here, okay, folks? My goal, all right, before we get to the quiz, was to really share how critical this power of attorney is to your future and to your assets and for doing it right. Doing it wrong, again, can lead to problems. Making sure you get it done right by the right firm is crucial. So where do you actually get the right power of attorney? That's going to be the statutory form, that's going to be durable, that's going to have the gift writer, that's going to be executed properly, that's going to have the modifications. Well, you do you get it from an online website? That's going to be Do you get it from Staples or some other store? The answer is no. Do you get it from the attorney closest to your house? The answer is no. You also don't get it from your real estate attorney or your criminal attorney or your divorce attorney. This is particular to estate planning attorneys, elder law attorneys, or what we call ourselves elder care attorneys. So that is where you get the right power of attorney. All right. LegalZoom, Rocket Lawyer, those are online companies, and there's 100 of them. The problem is they're mostly national in nature. They might have the New York statutory short form. They're not going to have the modifications. They're not going to have you and oversee as you are executing it properly. It just gets very messy. All right. So definitely not a website. Definitely not at Staples. And an attorney that, and again, we see powers of attorney executed by attorneys. Okay, I'll give you an example. As I'm going to start wrapping up after this. It was about 2 years ago at this point, and I tell it because it's such a shame. A woman came in, potential client. We ended up working with her, and she said, "I have the power of attorney, like so many do, and I just had it done, so I think I'm going to be fine with that." I said, "Wonderful. Let me take a look at it." So it was a 2000, let's say that was an 18, so it was a 2017 power of attorney, right statutory form. It had the gift writer. However, it was missing the modifications. Okay. So the woman I'm sitting across from was perplexed and upset because she just paid to have this done less than a year ago. Now, what really upset her was she goes, "But the attorney told me the one I had before this was wrong, so they needed to update it." I said, "Would you happen to have that prior power of attorney?" And she did. She took it out. And guess what? That power of attorney from 14 or 15 was fine. It was accurate. It was now revoked, however, by the 2017 one. Going to an attorney that does this stuff every day is worth its weight in gold. Okay. Yes, I want our firm to help you. It doesn't have to be. I want that, but it doesn't have to be. Go to an attorney that knows what they're doing. Okay. There's what's called a certified elder law attorney. That's that CELA after my name. Those are the firms that have demonstrated and take the board exams to prove that certification. Then there are plenty of other good attorneys that do know this stuff. They're just not certified. Okay. Go to their website, see what services they do. If they are divorce attorneys and DWI and criminal attorneys, and they also do elder law, that's not going to be beneficial to you. Okay. I don't do family law. I don't do personal injury law. This is all we do because it requires that type of focus. Okay. Now, where do we put these powers of attorney into play? In our estate planning services, which are generally for younger folks, 30s, 40s, 50s. Revocable trust planning will always have a durable modified power of attorney built in. Our elder care protection plan, that's for folks 65 and above looking at long-term care in the future. How do I protect my house? How do I prepare for care? The power of attorney is going to be a part of that elder care protection plan. And ultimately, the power of attorney is crucial when it comes to life care planning. That's our service where my attorneys and my elder care coordinators, my advocates, all work together as one team to help with the Medicaid work and the care advocacy work to make sure we're protecting the most assets, that we're getting Medicaid to pay the care bills, and that we're helping your loved one get the best care possible. So in that life care planning scenario, if there's no power of attorney, but we have capacity, we're doing that power of attorney as soon as possible. Okay. If there is no capacity, then obviously we have those other guardianship alternatives we were talking about. But our powers of attorney, we're doing them for all of our planning services. Okay. I want to conclude with a quote from Milton Friedman. So Milton Friedman was he was an economist, won a Nobel Prize, Peace Prize, or in economics back in the 70s. And what he said was this: the power to do good is also the power to do harm. And not trying to get all dramatic on you here, but the reality is that you can do something properly or you can do something improperly. And when you have the ability to appoint somebody to help with these important matters, you could do it right or you can do it wrong. Okay. So the goal here was to share how to do it good and not to cause any harm by doing it wrong. All right. Thank you very much. We ended up pretty good time wise, but I'm here for any questions, of course. You can email me directly if you have questions. I'll see what we have on the boards right now. Email is brian@tullyelderlaw.com. That's Brian with an I for those on the phone. Tully Elder Law, TULLYELDERLAW.com. Or our phone number, call the office, 631 424 2800, 424 2800. We serve throughout New York City, Westchester as well, and of course, Nassau and Suffolk. All right. Again, thank you. It's our plan to do these every Wednesday. And now let me see if we have any questions. All right. Any questions at all, folks? Okay. So mom is 91, has 3 children, house is in her. Okay. A question about mom's house. So mom is 91, there's 3 children. That is planning is called for there. So what we'd be looking at is asset protection planning. It could be the elder care protection plan I just referenced, or it could be the life care plan if there are any care needs. So the house should be, depending on the circumstances, moved into what's called an irrevocable asset protection trust. There 1000% should be a durable modified power of attorney in place as well. Okay. But again, it has to be a part of a comprehensive plan to make sure that it's done properly. Okay. Any other questions or comments? Okay. What if, all right, so if you're not sure if the power of attorney was executed properly, then we do offer free consultations. You can bring in, or obviously at this point, you can email to me a copy of the power of attorney, and I'll look at it during the consultation, and we can decide if it's valid or if it needs to get updated. Another question. So dad did a power of attorney, 2 brothers, 1 brother's not involved. You have to look and see if the power of attorney requires you two to act together. If it does, then you have to deal with the issue. If the power of attorney allows you to act separately, then you can handle what you've got to handle without the other agent involved, and you should be able to move forward without his or her involvement. Okay. Can New York City co-ops be handled the same as real property? So a co-op, as the question points out, is not real property. It's personal property. It's shares of stock and a lease to live there. Generally speaking, the answer is yes. A co-op has all the benefits that real estate does without the ownership of the land. Okay. Where we often see a difference is when we're trying to protect a person's home, and it's their house where they live, or a townhouse or a condominium, they have a deed, and they can transfer that deed to an irrevocable trust, and we can do that without anybody's approval. With a co-op situation, you're going to have to get the board approval for the transfer into the trust. The first question is whether they even allow transfers to trusts, and then they're going to have to review the trust. They bring in their attorneys. But at the end of the day, it's worth going through that process if we can protect the asset from long-term care and from Medicaid down the road. Okay. All right. Any other questions, comments? Thank you very much, everybody. Thank you. My pleasure. All right. As always, a copy of this will be sent out to those that registered. And again, it's on our website and Facebook as well. And please tell your friends and family about these so that we can kind of get the word out and try to help some more people. Thank you. Stay safe and have a great day. Bye-bye.